Thank you, and welcome to the 4th International SEEDS Conference side event, jointly organized by the Notre Law School Global Human Rights Clinic and the UN Office of the High Commissioner for Human Rights. My name is John-Marc Brissot. I am the staff attorney at the Global Human Rights Clinic at Notre Dame Law School. Over 20% of the United Nations member states are classified as small island developing states. SEEDS are disproportionately affected by climate change and are facing unique economic, environmental, developmental, and climate challenges, with rising sea levels, increased natural disasters, and devastating impacts on livelihoods and human rights. This side event will bring together experts, policymakers, and civil society to discuss the human rights dimensions of climate change and identify effective responses. During this event, speakers will evaluate the application of human rights, particularly the right to development and the right to a healthy environment in the context of SEEDS. Investigate regulatory and policy measures in SEEDS to advance these rights in the context of the increasing challenges from climate change. Analyze available reparations and other accountability mechanisms through case studies for issues related to these rights in SEEDS. And finally, disseminate project findings globally to promote awareness and action for enhancing human rights, notably the right to development and the right to a healthy environment worldwide. First and foremost, let me introduce the panel. To present the death study research and data set, we will have Professor Diane Desierto. She is a professor of law and global affairs, faculty director of the LLM program in international human rights law, and founding director of the Notre Dame Law School Global Human Rights Clinic, jointly appointed as tenured full professor at the Keough School of Global Affairs, University of Notre Dame, Indiana. Faculty fellow at Clark Institute for Civil and Human Rights, Kellogg Institute at International Studies, Liu Institute on Asia and Asian Studies, Porty Institute on Global Development, Nanovic Institute of European Studies, and co-principal investigator, Notre Dame Reparations Design and Compliance Lab, as well as an honorary appointment as Professor of International Law and Human Rights from the Philippine Supreme Court's Judicial Academy of the Philippines. She specializes in international economic law and development, maritime security, comparative public law, and Asian law. She is also a former chair rapporteur of the United Nations Working Group on the Right to Development, former faculty and director of studies at the Hague Academy of International Law, and currently editorial board member at the European Journal of International Law. The presentation will be followed by a discussion with the following experts. Ms. Shyami Puvi-Manasinghe. She is a human rights officer at the Office of the High Commissioner for Human Rights in Geneva, where she supports its mandates on the right to development, international cooperation, and the social forum. She served previously as senior lecturer at the Faculty of Law, University of Colombo in Sri Lanka, and with non-government organizations in Gaborone, Botswana. Her publications include the book, Foreign Investment, Human Rights and Environment, a perspective from South Asia on the role of public international law for development, human rights, including the right to development, international solidarity, and cooperation, economic, social, and environmental justice globally in South Asia. Next, Ms. Heike Ellefsen. She has almost 30 years of human rights, legal, political, and developmental work experience with the United Nations, the Council of Europe, and civil society. Until 2020, she was Senior Human Rights Advisor to the UN Country Team in Bangladesh and to the UN Development Group Asia Pacific in Bangkok. As Deputy Head of the UN OHCHR, Regional Office for Southeast Asia, She established a country program for Myanmar and coordinated policy and information on the Human Rights Council's special procedures at the Office of the High Commissioner for Human Rights in Geneva. She also served with the UN Division for the Advancement of Women and the UN Development Fund for Women in New York as Council of Europe representative in Bosnia-Herzegovina and with Amnesty International's legal office in London. Next, Ms. Emlyn Sialei-Lolahia. She is a Tongan civil society leader, women's advocate and activist, working and based in Suva, Fiji, as the executive director in Pyongyang since 2019. She has brought 12 years of experience from her previous role as executive director of Civil Society Forum in Tonga to the region in the area of coalition building on issues as diverse as ethical leadership, women's access to finance, women's leadership and political participation, seabed mining, climate change, humanitarian localization, and locally led development. She represents the interests of the Pacific Society and a range of regional and international fora, specifically in areas of human rights-based approach, governance, public finance management, and institutional building, effective and informed participation of citizens in the decision-making to ensure the interest and well-being of Pacific people are safeguarded. Next, Mr. Zachary Phillips is currently employed as a Crown Counsel within the Attorney General Chambers of Antigua and Barbuda. Zachary has a Bachelor of Science in Political Science and a Bachelor of Laws in the LLM in Public International Law. As such, his main area of service is an international law unit at the Attorney General's Chambers, where he is responsible for representing the interests of Antigua and Barbuda in various multinational fora. In his capacity, Zachary has attended the UNFCCC COP26 in Glasgow as the legal advisor of the Minister of Health and Environment. He's also served as legal advisor for a few of global climate funds implemented by the Department of Environment within Antigua. Next, Ms. Talia Viveros Wihara. She has a PhD in global inclusion and social development from the University of Massachusetts in Boston, where her dissertation explored the intersection of health crisis and climate change litigation in Latin America, particularly in relation to vulnerable populations. She holds several prestigious academic and research positions, including Senior Research Fellow at the Max Planck Institute in Comparative Law and Public Law in Germany, postdoctoral research at the Trans-Litigate Project, Public Law and Governance Department at Tilburg University in the Netherlands, and project affiliate research of the Global Health and Human Rights Project at the Harvard Law School. Next, we have Professor Marie-Claire Cordonnier-Seger. She's a chair of the Sustainable Development Law and Policy and Director of Studies and Program Director at the Lucy Cavendish College, University of Cambridge. She's the Senior Director of the Center of International Sustainable Development Law, Executive Secretary, Climate Law and Governance Initiative for the UN Framework Convention on Climate Change, and Chair of the UN Convention on Biological Diversity, Biodiversity Law and Governance Initiative. And now, with that, I'm going to turn over to Professor Diane DeCialto for her presentation.
Thank you very much, Jean-Marc, and thank you for those who are participating in today's side event. I'm especially grateful for the discussants who have made the time to be present, for the participants who are here for this discussion, as well as for the presentation of data from the research on our end at the Notre Dame Global Human Rights Clinic and the Reparations Lab. If you will permit me, I will just share my screen and speak for the remaining 18 minutes on the data that we have gathered, as well as from our findings in relation to climate actions affecting SIDS. So the research here is primarily presented on two fronts. First is a forthcoming journal article with the Santa Clara Journal of International Law, which clusters 5 years of research on the human right to development, small island developing states, and climate change reparations. We used mixed methods and interdisciplinary tools from law and social sciences, as well as, and drew from the expertise of different team members from both law and social science disciplines. The discussion I have today will focus primarily on parts B and C of the outline. I think it's self-evident to the fourth SIDS International Conference that small island developing states are indeed the world's most climate vulnerable, and we are seeing the empirical research come out of that. But the main arguments that I do want to bring to your attention are not just the leadership that SIDS have taken on sustainable development and human rights, but how to bridge the gap, most importantly, between vulnerabilities assessments that are now taking place, as well as climate actions that are contemplated both under existing nationally determined commitments of states and the forthcoming round of new NDCs that states are supposed to submit by 2025. To that end, it goes without saying that the climate vulnerabilities of our small island developing states are shared. The climate vulnerabilities extend to food resilience, to ecological challenges, to developmental challenges, to governance challenges, to a whole host of challenges that were captured in the 2024 high-level panel on development of a multidimensional vulnerability index. Now, the MVI framework that the UN produced gave very concise individual country studies on vulnerabilities and resilience, country profiles for each of the 39 SIDS, capturing social, economic, environmental factors that structurally combine to generate the vulnerability and the largest portion of vulnerability to small island developing states. To this end, knowing that SID states are indeed the most climate vulnerable, as a matter of law, it is also important to realize how central SIDS have been in establishing leadership on sustainable development and human rights since the 1992 Rio Declaration to the present. It was in Agenda 21 when the very first normative direction was set on looking at small island developing states as a special case for both environment and development, being both ecologically fragile and vulnerable, looking at the integrated considerations of vulnerability and the particular major setbacks to socioeconomic development for SIDS that create special challenges to planning and implementing sustainable development. The 1994 Barbados Declaration and Program of Action was the very first international instrument at the time that explicitly argued that there should be consideration for both a human right to development as well as human rights-driven international actions to enable that climate resilience and sustainable development for SIDS. Subsequent instruments that were passed at the United Nations in the early 2000s saw, or rather witnessed, the creation of the Caribbean Community, the Pacific Islands Forum, as the convening or negotiating organizations that drove international cooperation for SIDS in these regions. The Pacific Islands Forum, for example, developed its own Pacific Plan that was more focused on law enforcement cooperation, marine and scientific research, conflict prevention, confidence building measures, whereas the CARICOM focused on integrated management of the Caribbean Sea area, linking considerations of land-based pollution, poverty and development, technical assistance, and natural resources management. We see a shift in the chain, or a shift in the instruments that look towards that cooperation after the massive climate disasters in the early 2000s that led to the 2005 Mauritius Strategy and Program of Action that tried to mainstream into the United Nations the SIDS Environment and Development Agenda throughout the UN system. This also emphasized the national level ownership of SIDS of their own sustainable development programs, while the UN focused on another level on garnering regional and international cooperation, financing, and technical support for these initiatives, which would be nationally driven, more often focused on disaster risk reduction, renewable energy systems, ecosystem management, and economic development priorities in education, health, transport, communications infrastructure, finance, among others. The result of this sort of two-tier dynamic were that different SIDS nations have very variable results. They largely depended on each SIDS nation's proposals and the willingness, the counterpart willingness or unwillingness of international development banks and sovereign lenders to finance these proposals, or even it also depended on whether or not there was consistency with the international aid agencies in providing the needed technical and financial assistance. However, it is also clear on the normative front that SIDS have led the growth of sustainable development as an institutional, but also as a legal principle, drawing on both environmental and human rights protection, especially on economic, social, and cultural rights. They either proposed, amended, or quickly signed softer instruments that help to drive and establish this understanding and nexus, and we see this in the Millennium Declaration, the World Summit outcome, the Monterrey Consensus, the Doha Declaration, among others. By 2014, when the United Nations first declared the International Year of Small Island Developing States, the Samoa pathway was adopted. And here it is a crucial year, 10 years ago, because this expressly integrated human rights protection as the path for SIDS sustainable development. This time, SIDS started drawing on international human rights law, both treaty and customary international law, to invoke binding international legal obligations in the design of cooperation programs and assistance. Our textual analysis at the Global Human Rights Clinic of the UPR submissions of all SIDS states, using our own human rights database and analysis project that was originated by one of our alumni, Professor Jean-Marie Kamatali at the Ohio State University Law School, revealed that the individual UPR submissions of SIDS states to the UN human rights system have for many years very closely identified their respective national, ecological, and economic vulnerabilities with deficits in the protection of civil, political, economic, social, and cultural rights. Many SIDS individually premise their need for international cooperation and technical assistance on the climate vulnerabilities and sustainable development challenges to international human rights treaty law. So it was not as if the international system had not been aware of that crucial legal nexus and how that legal nexus was being addressed either in the negotiations pillar or, as we will see later, increasingly in the adjudication pillar and dispute settlement pillar in the United Nations. We see that sustainable development eventually gained so much traction as an international law norm that by Agenda 2030, we see 22 special provisions for SIDS, drawing directly from the Samoa Pathway and the related instruments, the Barbados Declaration and Program of Action, the Mauritius Strategy, among others. And so the agenda for sustainable development is grounded on international and informed by international human rights law, including the Declaration on the Right to Development. At the same time, we see currents of how the right to development, which originated in its codification from the 1986 Declaration on the Right to Development, to the current pending draft covenant on the right to development as of 2023. There's also been a counterpart parallel move from a declaration to a legally binding instrument. I pointed the site in there that traces the specific sort of normative journey of the right to development into its present form of pending codification. What we see here is that the crucial innovation is in the definition of the right to development under the draft covenant that looks at the right to development as a right of individuals and of peoples to participate in, contribute to, and enjoy civil, cultural, economic, environmental, political, and social development, and the highlighted phrase, that is indivisible from and interdependent and interrelated with all other human rights and fundamental freedoms. In truth, this is exactly what SIDS had been asking for in the parallel track since 1992, when SIDS put forward the notion of the integrated compliance with human rights law in all related climate actions. At the same time, we see the development of the UN Human Rights Council recognizing a mostly SIDS-driven proposal for a human right to a clean, healthy, and sustainable environment, especially in the resolution which recognizes this right, affirms this right, and calls upon states to adopt policies, enhance international cooperation, strengthen capacity building, and continuing to share good practices to scale up their efforts to ensure this the realization of this right for all. Knowing, therefore, that there is this convergence normatively, legally, institutionally throughout the United Nations system, with the heavy influence and efforts, cooperative efforts of SID states, the key issue today is how to bridge the gap between SIDS vulnerabilities and the kind of climate actions that are now being contemplated through international law. The argument we've made here at the Global Human Rights Clinic is that we have to go back to foundationally operationalizing the principle of effectiveness, giving effect to all environmental and human rights treaties at the same time. That is not in itself an easy quandary. As we argued at the Inter-American Court on Human Rights fairly recently in their advisory opinion proceedings on climate emergency and human rights, there's a very specific treaty language, the 12th paragraph of the Paris Agreement, that explicitly says that to take action to address climate change, parties should indeed respect, promote, and consider the respective obligations on human rights. And here, the specific vulnerabilities of persons, especially their right to development, was explicitly recognized in the treaty language itself. This then raises several questions on how this inflects continuing international legal commitments on how to ensure cooperation and assistance for SID states that have long asked for the merger of human rights and sustainable development. There is existing language, and we point out to these instruments in the Covenant on Economic, Social, Cultural Rights, the Draft Covenant on the Right to Development, the Framework Convention on Climate Change, the Kyoto Protocol, Paris Agreement, the BBNJ Agreement, the line of COP decisions up to the recent global stocktake, as well as softer instruments such as the 2022 Kunming-Montreal Global Biodiversity Framework, that already explicitly call for this merger to inform the nature of international cooperation and assistance. If that is the case, therefore, what explains, if the law seems to have been moving in this direction, what explains the continuing existence of the gap? One thing that we have discovered at the Global Human Rights Clinic, as well as at the Reparations Lab, is that while so much effort was done and has been marshaled at the negotiations pillar, the variability has resulted in very difficult results and uneven asymmetric results for SID states. The result is that while now we see increasing climate litigation vis-a-vis climate reparations issued or awarded by domestic, regional, and international courts, tribunals, and bodies, each separately asking for forms of reparations such as compelling mitigation, compelling funding for adaptation, climate financing, loss and damage issues. These are all very disparate, unfocused, and largely variable climate litigation taking place all over the world. Our data set at the climate change data set of the Reparations Lab draws from 144 judgments thus far of domestic, regional, and international jurisdictions that all have already issued reparations related to climate change litigation, 100 judgments from domestic tribunals from Africa, Asia, Latin America, North America, and Oceania, 45 international judgments from UN treaty bodies, the European Union, and the Inter-American Court of Human Rights, and examines 387 reparations measures in total. What we have preliminarily seen from our data is that while there has been a proliferation or a frequency of pecuniary reparations, we have a longer list of non-pecuniary reparations that have been ordered by different tribunals. Not all of this specifically involves small island developing states' very clear vulnerabilities. These look at the landscape of the entirety of climate change reparations and the many respondents, different types of respondents and plaintiffs in these cases. We will see that many of the reparations sought are guarantees of non-repetition that also seek to regulate, modify, interpret, or annul regulations, mitigation measures, and adaptation measures, duties to perform environmental impact assessment. There have been some landmark cases on denying or revoking permissions and concessions given to the private sector, to transnational actors, especially the extractive sector that generates these emissions. And there have been a few that have related to human rights explicitly and the declaration or recognition of obligations. Many reparations measures have also involved conservation, restoration, and protection. Some actually compel action plans for human rights protection alongside climate action. The findings, therefore, are that normative measures are the most common design of remedies for climate change-related measures, or rather cases. So courts, tribunals, and treaty bodies are all mostly ordering governments, if not governments, to adapt the domestic legal system to regulate, modify, interpret, or annul their regulations. Many legal instruments that have been invoked in these cases have measurable legal obligations as to emissions reductions. International courts are mainly focused on ordering regulation, modification, interpretation, or annulment of these regulations, whereas domestic courts tend to focus on the adaptation of legal systems, rules, and norms to directly decrease emission levels as mitigation measures that are officially ordered by the courts. There are very few courts in the world that will order broad reparations measures, with most of the innovations in reparations design emerging from courts in the Americas, specifically on conservation, restoration, and remediation, as well as practical measures to ensure mitigation and adaptation targets. But most importantly, for our purposes today, very few courts are focusing on designing reparations that specifically address harms to the most climate vulnerable. And we're talking here about states such as SIDS, specific communities within states, peoples, groups, or persons. This is a huge gap, and one that we're seeing is coming across from the very disparate attempts at climate litigation around the world. What this also tells us is that, and as we have argued at the clinic, is that there's also a counterpart deficit when it comes to local climate actions. When NDCs are being concluded or prepared, they're not all states, especially the major emitters, they will not necessarily integrate their human rights law commitments into their NDCs. Neither will they purposely integrate them into climate project approvals or debt and equity arrangements to finance climate adaptation projects. This for us is a gap that says there should be some form of human rights audit that should be done at the country level especially for SIDS on climate adaptation projects. We've done a sample of this human rights audit over at Notre Dame, and we've done it and presented it at the United Nations Department of Economic and Social Affairs, specifically this case study that looks at how to merge realizing the rights to water and sustainability and the corpus of interdependent human rights with the kind of questions that have to be undertaken at the operational level with water-intensive industries. And we've started building up the case studies to this end. On that point, I think I've finished the 20 minutes. I'll be happy to continue the discussion with the rest of the panel. Thank you.
Thank you, Diane. And now we turn to Puvi Manashinge Shami for discussion.
Thank you, Professor Brissot, also for your leading role in this study and in co-organizing this event. Our congratulations to all the authors led by Professor Diserto and for her excellent presentation. Greetings to all from OHR in Geneva. It has been a while since Diane and I first discussed collaborative research on the challenges of SIDS through a human rights lens, with a view to supporting their transition from vulnerability to resilience. The study before us today has ventured beyond those exchanges, expanding the horizons and exemplifying with cases. The data analyzed is invaluable and points to possibilities ahead. From Kiribati to Barbados and Maldives to Comoros, across the Caribbean, Pacific, Atlantic, and Indian Oceans, and the South China Sea, small island developing states are on the front lines, faced with the most disproportionate impacts of the climate crisis and also pollution and biodiversity loss. These are compounded by many other challenges, from the COVID-19 pandemic and debt running deep. We support the study's call for strong responses grounded in universal, indivisible, interrelated, and interdependent human rights. And we recall that with their knowledge of the sound management of island resources, local communities facing the lived realities of sea level rise would be key in framing these responses. Identified as underutilized opportunities, the study recommends that the right to development, or RTD, and the right to a clean, healthy, and sustainable environment be the legal foundations for assessment of climate actions for SIDS. Indeed, these can enable other human rights, from food to water and health to housing, and vice versa, in mutually reinforcing ways. As my area of focus, I will speak briefly on the relevance and reach of the RTD, or right to development, in this context. Sorry. Integral to the declarations of Barbados, Mauritius, the Samoa Pathway, and charting the course toward resilient prosperity for SIDS in Antigua and Barbuda right now, RTD implementation still straddles uncharted waters. Yet, the challenges posing existential threats to SIDS, their peoples and cultures, go to the heart of the RTD. Built on an edifice of international legal principles and elements, not least a social and international order in which all rights and freedoms can be realized for all, national sovereignty, sovereign equality, and territorial integrity, interdependence, friendly relations, and cooperation among states, and their duty to cooperate in ensuring development and eliminating obstacles to development. The right of all peoples to self-determination and sovereignty over all their natural wealth and resources, equality of opportunity for development for nations and peoples, equality and non-discrimination in all forms, including for women and girls, youth and children, older persons and persons with disabilities, indigenous peoples, minorities, migrants, people of African descent, the poor and the vulnerable. The right to development aspires to create an enabling environment for development for all. To realize the full range of its principles and elements and all human rights across the spectrum, it enshrines the right of all individuals and peoples to contribute to, participate in, and enjoy economic, social, cultural, and political development, both in process and outcome, wherein all human rights can be realized for all, based on free, active, and meaningful participation and fair distribution of development benefits among peoples and nations, redressing inequalities within and between states. To this end, it recognizes that states have the right and the duty to make national development policies and the primary responsibility to create national and international conditions favorable to realizing the right to development, to act individually and collectively to make international development policies with sustained action to promote the development of developing countries, providing the means and facilities to foster their comprehensive development and economic and social reforms to eradicate social injustices. Premised on international solidarity, the RTD amplifies duties of the international community. States, international financial institutions, multilateral development banks, and all stakeholders are called to act to mobilize resources, including now for adaptation and mitigation, finance, infrastructure, technology, renewable energy, disaster risk reduction, fair, equitable, non-discriminatory trade and investment, debt relief, policy and fiscal space. North-South, South-South, triangular, and all forms of regional and international cooperation, strengthening institutions and capacity building for quality data. We actually did a study on South-South cooperation, in particular the IBSA, or in India, Brazil, South Africa partnership, as well as the India Development Fund, and how they help to rebuild after natural disasters in Antigua and Barbuda. And we saw the mutually reinforcing qualities of the right to development and South-South cooperation. The three levels of RTD responsibilities of states to their people, extraterritorial to people in other states, and collectively through international and regional organizations, further respond to the dire needs of SIDS. We support the study's finding that the design, implementation, financing, monitoring, and evaluation of international, regional, and domestic climate actions affecting SIDS must be based on human rights. As it points out, we will need less litigation if national legislatures and international lawmaking bodies embed human rights from the outset in the design and implementation of policies, plans, and projects towards developmental, environmental, and climate justice from the outset. To this end, along with the UPR, further work could look at the treaty bodies, the work of the treaty bodies and special procedures, which will add further value. In that context, the special procedures, several mandate holders did release a very good statement at the eve of the Small Islands Conference, or SIDS4, which we can share. We hope this is the first step in our sustained collaboration to support SIDS. As per Principle 3 of the 1992 Rio Declaration, the RTD must be fulfilled so as to equitably meet developmental and environmental needs of present and future generations. The Sustainable Development Principles enshrined therein and henceforth, including common but differentiated responsibilities and respective capabilities, polluter pays and precautionary principles, as recently recalled in the advisory opinion of the International Tribunal on the Law of the Sea, reaffirm the need to close gaps in principle and practice at all levels towards not disparate, but coming together towards the convergence of human rights, development, environment, law of the sea, and others for SIDS and beyond. Thank you.
Thank you, Shami, and I will turn to Heike for her presentation.
Thank you very much, Professor Brissot, and good morning from Suva here in Fiji, where I represent the regional office of the United Nations High Commissioner for Human Rights. We cover 16 countries in the Pacific, 14 of which are SIDS, plus Australia and Aotearoa, New Zealand. And it is a great pleasure to participate in this side event. I'd like to join my colleague, Shami, to congratulate the university for having undertaken this very important study. I think it will be very useful for us as human rights practitioners because we are closely following both law and policy developments which have an impact on human rights here in the SIDS where we live and work. Our office is part of the UN country team, and together with other agencies and also the regional organizations, which have an important role here, the Pacific Islands Forum, but also the Pacific Community. We work on joint programs or other action relating, for example, to climate change mobility, to civic space and climate security, to capacity building and protection of environmental human rights defenders, or on the impact of nuclear legacy and the nexus between climate change business and human rights issues, which are connected to extractive industries, including land and deep sea mining. So let me go right into my comments. I have picked 3 of the findings and recommendations of the study on which I'd like to comment. And one of the key findings, it's also been alluded to by both Professor Deserto and by my colleague Shyami, is that it really resonates with the Pacific, how much of a missed opportunity it is if one does not frame the triple planetary crisis, biodiversity loss, of climate change and environmental pollution and degradation as a human rights crisis, because that is what it is. And what the document, what the study tells us is that seminal documents such as the Samoa Pathway are very much anchored in human rights. But what we see in practical terms is that there is limited acknowledgement of human rights commitments. And certainly in the ongoing discourse, in the very large variety of programs, projects, smaller initiatives, but also in policy dialogue and by and with governments, but also among development partners and financing institutions, and also to some extent in non-governmental spaces. The study notes that the seeming separation of the concept of development from the entitlements of human rights of populations within SIDS is a concerning element. And it also notes that the vulnerabilities of SIDS that have been estimated through certain recent models of assessments and indices for monitoring the implementation of human rights obligations, there simply is no capacity. This is not included in those studies and those new models. And it is obviously of concern that if there is limited or no information on what SIDS governments are legally obliged to do to respect, protect, and fulfill human rights of their populations and provide remedies for redress, and what non-SIDS governments and all the other governments owe to SIDS governments, for example, under the right to international cooperation under international human rights law. And if you will, if you're looking at the 2030 agenda, commitments under SDG 17, for example, to ensure respect for and the realization of human rights, then what message are we sending to those states? We are sending the message that to address the vulnerabilities experienced by SIDS populations, it is just simply a matter of contextual continuity, contingency, and resource expediency. And resource expediency is obviously something that is problematic, because if we are not recognizing that we are dealing with a more urgent matter of seeking to design policies that ensure the full implementation of human rights towards SIDS populations as something that we can legally demand in courts and other spaces, for which SIDS and non-SIDS governments can be held accountable, then that is of great concern to us. Because it also perpetuates inequalities between richer and poorer nations, and it betrays the polluter pays principles and enhances perhaps the notion that mere expressions of solidarity in Pan-Pacific partnerships may be sufficient, rather than firm commitments from states and international financing institutions, which are needed to take action and to make investments. When atoll nations of the Pacific, but also in other parts of the world, are under threat of sinking in the next 30 years or so, this lack of focus on binding human rights obligations is simply not good enough. And I would like to take one case in point, which is the right to a clean, healthy, and sustainable environment. Obviously, it has its substantive elements: safe climate, clean air, healthy ecosystem, biodiversity, safe and sufficient water, healthy and sustainable food, and a non-toxic environment. But it goes far beyond that. It refers to procedural rights, which are also, of course, civil and political rights. This means providing communities with access to information, including through environmental and human rights impact assessments, for example, and it means public participation that is active, free, and meaningful. We have seen the principle of free, prior, and informed consent very often referred to as the principle guiding engagement with indigenous populations, which are, of course, in the majority here in the Pacific SIDS. But it is one of the important initiatives and exercises and principles, and it's not just a tick off the box exercise. And this right and the aspects of these rights and the elements of this right to the environment are also often here in the Pacific, but also elsewhere, among the most contested and give rise to human rights violations of the right to freedom of information, association, expression, participation, especially in countries where public participation is a hard-won goal and where it is not perhaps coming naturally in policymaking and development planning, and it's not so easily won by empowered members of affected communities who are left most behind and who are often facing what we would call intersectional discrimination, i.e. women and girls or persons living in poverty or with disabilities. And this leads me to the third procedural element of this right to environment, which is that of effective remedies. I think it's important to highlight another finding of the study, namely that it is not at all coincidental that there's been a significant increase of climate change-based litigation seeking to compel states as well as private actors to fulfill their obligations, especially on mitigation. Future strategic litigation and advocacy can further advance these opportunities for the enjoyment of human rights in the SIDS. We believe so. And I'd like to just refer to last week's seminal law of the Tribunal of the Law of the Sea advisory opinion on the request submitted to the tribunal by the Commission of Small Island States on Climate Change and International Law. The tribunal concluded that anthropogenic greenhouse gas emissions are pollutants under the UN Convention on the Law of the Sea, and that states have the legal responsibilities to control them, and that, of course, developing countries or developed countries have to control these emissions faster than developing countries. We have seen an amicus curiae brief by the three rapporteurs on human rights and climate change, human rights and toxics, and human rights and the environment. And two similar cases are also on the obligation to mitigate climate change. They're pending before the International Court of Justice, as you probably all know, the case initiated by Vanuatu in the Pacific, and another case pending before the Inter-American Court of Human Rights. From the Pacific perspective, while this kind of strategic litigation by states has developed, cases of individuals that challenge the state on violations of the right to environment and climate-related matters, which also consider that these are resulting from failed policies or failed investments or non-investment in climate action, are still relatively rare. The study found that very few courts are, in fact, looking at designing reparations that specifically address harms for the most climate vulnerable states or communities or people or groups or even individuals. We have seen some cases before the UN Human Rights Treaty bodies, not specifically from the Pacific, but from Australia, for example, under the Human Rights Committee, the Torres Strait Islander case, or the Kiribati case, the Techota case. A man sought climate refugee status protection. This kind of strategic litigation, I believe, can help address crucial questions for SIDS. For example, in the future, we might see clarity on the question of what will happen with exclusive economic zones once islands disappear due to sea level rise, or litigation might clarify difficult questions relating to the immaterial loss and damage and cultural rights. We're aware, of course, that recent discussions have been going on in other spaces as well. Finally, I'd like to make one comment on the very valuable recommendation by the study to create human rights audits for all climate action projects. This is very welcome, and I would extend it to all environmental actions projects that also address pollution and loss of biodiversity. It would be very useful to continue this conversation, and I think we can build on the work of the human rights mechanisms, the treaty body special procedures mandate holders, the global UN human rights methodological capacity, and our presence in the field, both here in the Pacific, but also in the Caribbean, Africa, and Asia could perhaps help with that. And we're open to discussion. We do know that there are other initiatives that are going on that, for example, have been looking at human rights checklists and tools for audits and human rights evaluations, such as the Kiwa initiative. That is a multi-donor program, which has been going on here in the Pacific. So I think it will be very valuable if we can look at these issues, which can also encourage states to do more to ensure that human rights are part of this process of thinking about environment and human rights. And to conclude, I would like to stress once again the importance of studies like this, because for too long, I think we have seen that the discourse on human rights has been restricted to civil and political rights, where economic, social, and cultural rights were largely ignored, and development and a clean, healthy, and sustainable environment were seen as aspirations, but not rights. We must make sure that we all, by upholding our human rights as universal, as indivisible, as interdependent and interrelated, contribute to strengthening of human rights here for the SIDS. Thank you very much, and Venakada Kaleo from Fiji.
Thank you so much, Ms. Heike. And now we are turning over to Ms. Emmeline Siale Ilolahia, representative of the civil society. Ms. Siale, you have the floor.
Hello, can you hear me?
Yes.
I'm very sorry, I'm connecting from physically from the SID conference.
Ah, nice. Okay.
Yes, and unfortunately, all the rooms are being occupied for the different events. So I'm sitting outside one tree here and connecting to this virtual meeting.
Wonderful.
Greeting from the Pacific, or should I say greeting from Antigua and Barbuda for this meeting. Siale Ilolahia.
It seems like the microphone is off again.
Can you hear me now?
Now it's good.
Okay. Thank you for the introduction. So I'm Emmeline Siale Ilolahia from the Pacific Islands Association of NGOs, a regional network of civil society across 24 countries and territories in the Pacific, which a lot of our work is around giving voice to public policies formulation that is centered on Pacific values and development effectiveness principles, but also on people-centered development. Just reflecting on the presentations from the study, which I really appreciate a lot of the things that has been shared from the study that we can actually pull to support or inform the work that we do in the region. But my attention was drawn to the questions around bridging the gaps. Since the Earth Summit in 1992, where SIDS was recognized as a special case. It's, fast forward to 2024, that's about 30 plus years of the SIDS, and this is the fourth conference. And we are still talking about, the human right, basic right to sustainable development, but at the same time looking into the environment dimensions of things. And so, with the theme that we are now looking at charting the course towards resilient prosperity, in the Pacific, we have our 2050 strategy. And so, for civil society, we are inspired that the resilient prosperity be strengthened by the deepening focus areas of the regional priorities in the 2050 strategy. And it does bring the transformational inclusive development in the center of the SIDS development, which it must be all for SIDS people. It's not just for some of them, but also all for the SIDS people. Gender equality must be included. The inclusion of gender and sexual orientation minority, the inclusion of people with disability and children, young people, migrant workers, and a strong focus on human rights must be the forefront of development approaches. This requires not only ensuring the voices of most marginalized are included in the decision-making and programs, but also focus on addressing the systems and the structural drivers of poverty, inequality, and injustice. And this is where we actually, really appreciate the sharing of the study, because it's related to that, in terms of where do we see some of the things that we need to do that can actually bridge that gap, that we could not continue to come up with another outcome, communique or another agenda for SIDS for this one. But how do we see inclusive of not just the marginalized, but civil society voices need to be part of this process so that we can be able to hold our leaders accountable. Those that are at the policy officials who are here to articulate on what does the SIDS new decade of priorities, but it's also in terms of that there are actions with this. So we also recognize that there need to be a strong political leadership. And I'm talking about in response to the gaps that has been identified. There must be inclusive, accountable, specific focus on participatory governance, recognizing the safe civic space to develop and invest in the leadership, advancement of not only political governments, but also leadership of traditional faith-based civil society and community, particularly our own women and young people. This is not a time when we're just saying, okay, we sit around and wait until our governance, our government's institutions are taking the lead, our politicians and our government officials. No, it's a need to be, political leadership and leadership at all levels. We also need to look into the regionalism of most effective, and countries are also strong. Regional mechanisms are a valuable tool for sharing knowledge, ideas, and resources, amplify the voices of the Pacific. However, engagement and investment in regional mechanisms should not be at the expense of investment in governance and coordinations at the country level. This includes supporting the legitimate self-determination aspirations, historical pride, nuclear legacy of our Pacific people. We should not be just talking about development, but we should also look into the aspirations of our people for self-determination. Right now, as we speak, we have situations in New Caledonia, for example, which our Kanaki, our indigenous people, are fighting for their self-determinations. What does development look like for them, where there are still influence of political powers, but they are not being given the right to decide what does development looks like for them. Resources and economic development, where SIDS prosperity is more than economic development, and financial mechanisms to be locally led. The Pacific values of well-being places prosperity in a holistic frame, encompassing environment and culture and community-led responses. We are also talking about things like the loss and damages. These are part of the climate change. Yet we know that we might have a good facility for loss and damages, but how do we ensure that those resources reach the very community that needed the help? So we need to have financial mechanisms that need to be locally led and accountable, across seats. There need to be, international financial compliance requirements of the donors need to be looked at. Government needs to improve transparency and accountability to communities for their national budget and expenditure. So we're not just like looking at the broader global level, but it's also the public finance management system within our own budget processes. Our community, particularly with the right to their land, in a time when we are looking at high debt of our government, and the alternative of revenue is already being considered to be coming from our ocean. How do we look at ocean economy, which is our base, the foundation of our resilience? Yet we are kind of out of looking at all alternatives to bring resources or bring financial to run support development. But where does the balance when we know that some of those commodities are actually the basis of our resilience in our community, our ocean? This is where people are going in to make sure that there is food at the table. The firewoods are coming from the forest, which is now being looked at as a climate swap for all the different climate issues that are often being outside of our community comprehension because they have not been part of that conversation. And it's technical in a sense that it may not be part of their daily conversations at all in the community. So where do we bring that as part of the bridging the gaps? The people-centered, the traditional culture knowledge that are embedded in the heart of our Pacific development, and that should be part of CITES as well. But also, just want to finish off by making the point in terms of connecting, which is a lot of the technology and the innovations comes in, strengthening our culture and our knowledge through technology, which does mean that we have to also consider the connectivity in bridging all that. However, across this technology access and ICT infrastructure is unevenly across the Pacific, and I'm sure it's across seats. Those without affordable access, many technology, it's important that we embrace technology advancement, that we do not lose our knowledge, values, and ways of communicating, integrating traditional knowledge, and valuing and protecting citizen data and stories are essential to keeping Pacific values and knowledge center of that technology advancement. Thank you very much for the opportunity to share my stories here. Appreciate that very much. Thank you.
Thank you so much, Ms. Siale, and for taking the time to come out and talk to us. Now we're going to turn over to Mr. Zachary Phillips for his remarks.
Hello, good afternoon. Just testing that the microphone's working.
Yeah, it's working. We can hear you.
Great. Okay, thank you very much for the organizers of this event, and thank you very much for extending the invitation to Antigua and Barbuda to share its reflections on the document that has been prepared. So going forward, the first thing that I want to highlight is that in preparation for this event, the government of Antigua and Barbuda, as well as myself as speaker for this event, have noted that it is really and truly a very useful, a very, I would say, innovative, and I agree with some of the speakers who have already spoken before me. It is a project that should be continued going forward, because we really do see, at least here from Antigua and Barbuda, that there is a lot more leverage, or I shouldn't use the word leverage, but there's a lot more success that is being reached now that we are involving on really focusing our arguments on climate justice in relation to human rights. Now, what do I mean when I say that? In my capacity as Attorney General's Crown Counsel, I have attended about 4 or 5 UNFCCC conferences. And those are negotiations that are steeped in the Paris Agreement and the UNFCCC treaty. However, those negotiations most times are taken from the viewpoint of states exchanging between other states. So it's really, what are the rights of states? What are the obligations of states? What can states agree on going forward as we attempt to address this issue? Now, in my capacity, I'm also the point person for Antigua and Barbuda's involvements in the different advisory opinions on climate change. Now, that would involve the ITLOS advisory opinion, the Inter-American Court Human Rights advisory opinion, and the ICJ advisory opinion. And we see that based on our arguments, based on our leveraging, based on our discussions, we see that human rights is one at the core of all of these issues as a starting point. But subsequently, and from a legal aspect, more usefully, human rights being the basis of these submissions is very useful as a way to counter any arguments that we come up against when we're discussing in a negotiation context in UNFCCC. So let me use a real example. When we discuss issues such as Antigua and Barbuda being in the hurricane belts of the Caribbean, it is a known factor that we receive hurricanes every year. Now, categories of hurricanes is a very real and disparaging list. A Category 1 hurricane is not the same effect on a country as a Category 5 hurricane. However, when Antigua and Barbuda was hit by Hurricane Irma in Category 5, which was a Category 5, in 2017, we saw a level of damage that we've never seen before. Just to be frank, Barbuda, which is a sister island, received 96% of infrastructure destruction, not infrastructure damage. 96% of infrastructure was just gone after Hurricane Irma hit. Now, in discussing that with our partners at the UNFCCC processes and the similar development discussions that happen on a state-to-state level, we're hearing a lot of rhetoric in response to our request for assistance that is more along the lines of development partnerships, in the sense that what is your GDP is questions that are being asked, or what percentage of a loan would be attached to the funding that would be given to rebuild. And it is really quite shocking from a SIDS perspective to be told that in the aftermath of such a catastrophic event, that we are meant to almost, in a sense, prepare a project request in the same way that we would be preparing for a GCF or an adaptation fund proposal in order to get sustainable support. Not to say that we didn't get support from humanitarian agencies, etc., but usually that support is of a different nature to the kind of support that we need to rebuild infrastructure such as the school systems, the hospital system in Barbuda, etc. So it's surprising in that context, in the aftermath of a storm, to be greeted with this, I would say, non-human rights approach. It's more of a project-based approach than a human rights approach. But then flipping the script and looking more at the more recent developments in the advisory opinion spaces, for example, we see that the rhetoric that is being discussed there comes from more of a situation of the right to self-determination, a situation of what about the rights, the protection of rights of human beings that are living in these spaces? So when we talk about hurricanes, or using our examples in the different submissions and the different panel discussions about submissions, it's no longer a discussion of how hurricanes affect, for example, the economy of a state. It's more so a discussion of, as a result of increased anthropogenic activity, as a result of the lack of climate action and climate ambition, we're seeing that the the responses of small island states and the support that small island states need is necessary, because the people within those vulnerable communities, the people who are living there, are really just left on their own to fend for themselves. And this kind of rhetoric, where I mean, I caution to use the word rhetoric even, because it is reality. So this communication of the reality that small island states are facing is something that I think it not only amplifies our arguments on the legal context, but it also reaches out to the humanity of the situation. And please forgive me if, this is not the most useful forum for a discussion about humanity. But I try to say, especially in legal fields, that a lot of persons think of this as a court case. But for small island developing states, it really is an existential question. As many of the previous speakers have pointed out, if things continue the way that they continue, islands may completely disappear. What does that mean for rights that are guaranteed by the state? What does that mean for those persons if they have to leave their state and go to another state? What is the reality that those persons have to face? Before we get to the stage of islands disappearing, what about exclusive economic zones? A lot of SIDS have big oceans where the economies are derived from a lot of activities that exist in the water. How do we continue with the grappling of the law of the sea conventions and different obligations under different regimes if we don't look at it from a perspective of what will the people have to experience if this continues, as opposed to what are the state's rights and obligations? So I note that the timing is not on my side. However, I just wanted to give that brief overview from a legal perspective, especially coming from a SIDS legal perspective. We do see the immense benefit of couching this discussion in relation to the human rights view and perspective of the persons who actually live there. Thank you.
Thank you so much, Mr. Zachary, for these great comments. All right, now we're going to turn over to Ms. Talia Viveros Uehara for her comments.
Thank you very much, Jean-Marc. Good afternoon and good morning. It's really a true honor to be here and to witness the presentation of this groundbreaking initiative by the Global Human Rights Clinic of Notre Dame Law School. I commend wholeheartedly Professor Diane Desierto and Aníbal Pérez Liñán and all their team for these extraordinary efforts. As Mrs. Shami, Mrs. Heike, Mrs. Emmeline, and Mr. Zachary have duly stated, this desk review truly casts a light on the path ahead of us to improve regulatory and policy responses to tackle how distinctively climate change impacts SIDS nations. So today I wouldn't like to proceed without absolutely expressing my thankfulness and how deeply humbled I am in sharing this stage with you all. And so I would like to briefly extend my appreciations to the Human Rights Clinic, to Professor Desierto, to Jean-Marc, and to all my co-discussants. Building on the findings that Professor Desierto just presented, I would like to reflect on a very few aspects of why is the gap that the desk review has identified happening. Namely, why courts aren't ordering reparations for the most vulnerable, despite years and decades of international lawmaking merging the right to development and the right to a healthy environment. Why aren't they getting at the gist of what the most vulnerable populations need and require, especially SIDS nations? So the question is, why are they living out, or are they underusing the development dimension, the human rights framework in all its full potential to really tackle the development dimension of climate change. So I would like to submit that it's useful in reflecting on this question, it's useful to look at the input dynamics of the litigation process and the legal structures, more precisely, who is actually litigating and the scope of the remedies they have at hand. So not shifting the question from how are courts responding to why are they responding in X or Y way. So my reflection in the next 3 minutes rests on 3 main points. First, as Professor Desierto has already articulated, domestic and regional climate litigation has increased since 2015. This wave has certainly not yet reached seed states. It holds, nonetheless, a potential to prompt climate action in favor of small island developing states through cases filed in other jurisdictions. And let me elaborate why. Specifically, there are 2 main pathways for litigation, for climate litigation, to contribute to realizing the right to development in an indivisible way and in an interdependent way with the right to a healthy environment in seeds. But we need to differentiate between the constellation, among the constellation of lawsuits that have been filed, the 2,000 plus lawsuits that have been filed worldwide. There are some lawsuits that have been filed in high emitting countries. These cases aim to hold states accountable for failing to take the positive measures and positive steps to prevent climate change, and thereby aiding to seek compensation for the adverse effects experienced by the most affected. In these cases, particularly the role of attribution science is and will be very crucial in establishing the causal nexus between the action and the damage. And there's a second body of lawsuits, which I will refer very briefly today, which are the lawsuits in global south jurisdictions, particularly in jurisdictions that whose human rights framework holds distinctive transformative potential. Professor Desierto just referred that most innovations are occurring in the Americas in this regard, and I will refer to the Inter-American region. So in this region, cases can leverage the human rights framework to promote South-South cooperation on very specific issues like climate displacement or adaptation. But for these cases to actually reach the gap that the Global Human Rights Clinic Desk Review has identified, there are 2 elements that are worth reconsidering. And these elements are tied into the input dynamics of the litigation process. The first one is the role of advocacy networks in designing cases, namely the transnational, how they thread together transnationally, and how the political economy on which they rest actually help them articulate their claims in X or Y way. That's the first element. And the second element is precisely the breadth of both the obligation of international cooperation and the remedial architectures to address various dimensions of damage. So I will just conclude by saying this, that as I speak, the Inter-American Court of Human Rights is holding a public hearing in Manaus in Brazil. There have been several submissions and contributions pointing to the need to interpret the duty to international cooperation under Article 26 of the American Convention in a way that is responsive to the South-South cooperation. So if the court interprets this obligation in such a way, it will open a legal avenue by which, if transnational advocacy networks are receptive to lawyering methodologies bottom up and not top down, well, it can actually lead to designing cases domestically that could actually prompt courts to be more responsive to the more localized and situated needs of the most vulnerable through international cooperation. I'll leave it there, and I'm happy to continue this discussion. Congratulations again.
Thank you so much for this great presentation. Now we are turning to Professor Seger for her comments.
Thank you very much, Professor Jean-Marc Brissot, for your excellent efforts and for bringing us all together and chairing us so ably. And thank you especially to my dear friend, Professor Diane Gerto and her entire team at Notre Dame and internationally. It is a pleasure to be joining you this evening. I'm actually here in the Fenlands, the eastern Fenlands of Cambridgeshire at the University of Cambridge, where we are witnessing yet another unseasonable rainstorm that is leading to yet more flooding of the low-lying lands that are crumbling into the sea. And while my family may come from this area, I was raised on Vancouver Island in the Pacific, which is not even a state, the southern tip of Vancouver Island, where the wildfires are burning the forests that we fought as young people to protect. And the ocean is starting to claw away at the cemeteries on the edge of Ross Bay and Dallas Road. And so I found the remarks of the discussants and also, of course, the conclusions of the study to be deeply meaningful and very powerful. As you can probably imagine, in small islands which are not even a state, the inhabitants, the peoples, the nations that are on these islands find themselves trying to challenge much larger groups, including entire provinces such as Alberta with tar sands, for their policies without even being able to come to the United Nations level. And so I felt that the points that were made, especially about the rights of Indigenous and local peoples, were very meaningful. And I would like to thank especially Dr. Shyami and Dr. Heike, as well as Advocate Emmeline and Advocate Zachary for their call to connect some of the domestic and international regulations with the findings in this groundbreaking study. I think I will simply note that as the chair in Sustainable Development Law and Policy here in the University of Cambridge, as its inaugural chair, part of our work is to find and promote studies like this one, and also, of course, to include and build on these studies in the books and articles that we develop as academics, and the studies that we continue to do to try to share knowledge. And certainly we will be relying on this work that you've done, Diane, in our new books that are coming out on climate law and governance, and in our new articles, as well as our new textbook, and in some of the briefs and papers that we are doing. But part of our work as well, I believe, as academics, is to intervene in international debates and try where we can to bring forward new knowledge and to bring forward new perspectives in these discussions. And it is in that light that I serve as Senior Director of the Center for International Sustainable Development Law, with about 200 lawyers in 70 countries around the world working together, and also as Executive Secretary of the Climate Law and Governance Initiative that was founded in 2005 in COP11 when all the countries came to Montreal, to McGill, where we were at that time based, and the 200 or so partners came together from different international organizations, highly climate vulnerable country delegations, especially their legal advisors, Advocate Zachary, and also, of course, law faculties and institutes and civil society organizations, such as the one that Advocate Emmeline represents, as well as Indigenous peoples lawyers from the North and from New Zealand and from many communities. And in that gathering and working forward since 2005, throughout the Paris Agreement negotiations, and also throughout the other COPs that have taken place since then, we have worked along four main areas. One of them, yes, is operationalizing the commitments that are in the UN Framework Convention itself, and then the Paris Agreement, in international law, not just contributing legal elements to the global stocktake or the market and non-market approaches that are being adopted, but also assisting with law and policy contributions to the international transparency and technology frameworks, or the financial capacity, compliance, and loss and damage mechanisms as they were being created, as well as trying our very best to promote synergies with other international legal instruments. Alongside that work, many of those lawyers in this transnational cooperation, and here the previous speaker is completely right, these are indeed collaborations that need to grow and intensify our efforts. We've been testing legal and governance tools for high ambition implementation, not just trying to innovate legal and governance instruments at the national and local levels for climate mitigation, adaptation, and resilience and finance, but also trying to create synergies within and across sectors, assessing legal barriers and strengthening capacity to overcome them among law and policy leaders, practitioners, and advocates in order to try to build some of that high ambition that is now so desperately needed. And we've even taken on as much as we can, working with the finance and investment sectors to try to push for, and we did this especially in the Glasgow COP26, net zero legal frameworks to enable climate neutral or climate negative investment in finance, not just scaling up climate finance investment reallocation of capital and sustainable global supply chains, but also addressing fossil fuel subsidies, climate risk disclosure, ensuring a just transition and decarbonization, especially through holding those responsible accountable in their private trade, investment, competition law, commercial, and corporate rules. Those three themes have brought together immense communities, not without their disagreements and debates, and certainly with as many failures as successes to date. But I think the fourth theme is the most relevant one here, and it's been joining together with the legal advocates of the Highly Climate Vulnerable Countries Forum inside the COP and much further beyond. And it's the theme that involves advancing climate resilience and justice, which is not just about engaging civil society and the legal community, including courts, law associations, and others in accelerating climate action, enhancing transparency, and ensuring accountability, but it's also about integrating rights-based approaches across all of the different areas of domestic and international law, which is beyond just advocating for the Warsaw International Mechanism for Loss and Damage to be implemented, and into what works beyond the effective financial and other structures that need to be set up, so that the types of frustrations that Advocate Zachary underlined very eloquently and very truthfully become a horror story of the past, rather than what is being told to countries who seek reparations and redress and retribution in the present. And Advocate Zachary, I'm sorry to say, but I have actually seen instances where loans are being offered for repair of climate loss and damage in areas which are, if you look at the most realistic predictions, due to flood completely in the next 2 decades. And this is happening increasingly in all regions of the world. It boggles the mind that people think this is acceptable in today's age. So I think what we probably need to emphasize here, and I'm going to close on just 2 points and 2 proposals, is that it is right now, for this study, of course, an incredibly key moment in history for international courts and tribunals to be informed of these opportunities and to be creative in terms of reparations and to build on good practices. We have seen, yes, domestic litigation increasing in countries that don't normally have it. But we've also seen at the regional level, the European Court of Human Rights, the Inter-American Court of Human Rights, starting to look very seriously at these issues. And this study can and must be brought to the attention of and inform those decisions as they move forward. Similarly, of course, and I've spent the week working with colleagues on the advisory opinion that just arrived from the International Tribunal on the Law of the Sea, taking into account, and I won't cite the detailed provisions that I wish to due to the limits of time, taking into account some of the findings in that quite crucial international advisory opinion and bringing them forward to the International Court of Justice advisory opinion that we are all working on, I think is critical. The second point, equally perhaps unsurprising, coming from the University of Cambridge, is that we need this new knowledge and this analysis. And I note, Diane, and I don't blame you and your team for it, the redefinition of the meaning of the term reparations and remedies in your study. And I think you've done that subtly and with great elegance and tact. And it's high time that you did so. And I would like to therefore, with two proposals, close. The first one is that your case study on water, which I'm looking forward to reviewing, is an excellent start, particularly if you can propose some of those reparations as good practices that could be then shared with others who are both bringing cases, as the previous speaker just mentioned, and also those of us who are part of international negotiation circles and domestic regulation drafting circles. And in particular, I would just advocate for, one, taking into account the decision of the International Tribunal on the Law of the Sea, land-based sources of marine pollution, and SDG 14 aligned case study. And then if at all possible, and yes, we will try to collaborate with this, we're not just trying to task you with additional work, either biodiversity in light of the Cali COP that is coming this fall for SDG 15, or of course, looking at what kind of reparations have been sought and granted by Indigenous peoples and First Nations. And I speak there as a pro bono lawyer who worked on the world's first sea claim together with the Nuu-chah-nulth peoples of Canada's Vancouver Island West Coast. And then the last proposal, which I think is one that far wiser minds than mine will surely be carrying forward, but I hope that we can do what we can to support it, would be that we do need to link this work and this incredible advocacy that Advocate Emmeline, and also, of course, this incredible expertise and effort that Dr. Shayami and Dr. Heiken mentioned. We need to link this work with the UNFCCC process to reconnect this picture of reparations to the discussions on how to implement the new Loss and Damage Response Fund, and to do that in light of the international advisory opinions that are coming out this year. And I think that is a piece of work that is urgently needed and could be done, whether it's by forming some kind of advisory council within the UNFCCC regime, or whether it's creating one of these transnational networks that the previous speaker spoke about so eloquently. I think that link needs to be made as we move forward, especially on the Loss and Damage Response Fund and on the next steps in the elaboration of that regime, because the kind of situation that Advocate Zachary faced is morally wrong, and it's against all human rights and all legal principles and precedents that we have established in the last hundreds or thousands of years as trying to become more civilized societies. And we will need to ensure that the processes are set in place to guard against those kinds of responses to the devastation that follows a climate change linked natural disaster. Thank you very much.
Thank you very much, Professor Seger. Now that the time has gone away, we have maybe one or two questions that we have been sent. One from Nicholas Smith. I don't know if he's here. What can the global legal community do to influence positive change in the economic advancement of small island states? I don't know who wants to take that on.
Perhaps I'll just venture a short response to this one. First and foremost, let me thank all the discussants for your very rich, very valuable views. I'm of the school of thought that the collaborative and collective learning process gets us to solutions better, and no better than to hear from other colleagues and from their own experiences and expertise. We do, and I am very grateful to the UN Office of the High Commissioner for Human Rights for this collaboration, first thinking about that leap from vulnerability to resilience, back when Dr. Shami and I were talking about this well over a year ago, in fact, a year and a half ago, and to get to this point, at least, of releasing the results of the study. The question that is raised by Nicholas is an important one. In fact, it's the kind of question that leads to what do we do next, right? Because we're in the era of multiple adjudications with multiple efforts. But I agree with Professor Cordonier that we really need to start looking at good practices and start informing, or at least providing this information to the UNFCCC process. I feel like there's a track of discussions that are taking place at the human rights side, looking at vulnerabilities, but it's not bridging over to those who have to start planning the climate actions for the next 10 years or even for the next 20 years. So to the extent, and we are also dissecting the advisory opinion from ITLOS and connecting that with what is possible. And, there's one sentence in the advisory opinion where the tribunal notes the human rights concerns arising from the existential threat to climate change. That in itself creates so many doors from the fact that there's that official recognition from that. I agree that there is a need for the transnational legal networks. It is my hope that this event is the first of many such events that will bring the collaboration of the world's best minds on the subject, because the legal community has to work on all fronts. It has to work not just on the litigation, but it has to be proactive about prevention. It has to be very proactive about policy making. This is where the work of the University of Cambridge is definitely something that we hope to support and to collaborate with as well. But there's also the need to also help reinforce political leadership. And it strikes me very much also from my standpoint, growing up in the Philippines, in a very small island developing state where flooding was normal, that leadership has to be informed. And to the extent that Ms. Emmeline spoke about that, that was so crucial. In regard to what Advocate Zachary spoke about earlier with respect to some of the troubles in regard to what the legal community can do, I think the legal community is doing a lot in multiple streams, but not necessarily together. And so to the extent, for example, that we've had the longest lingering problem of why do we have to deal with challenges in regard to the insurance sector for the small island developing states? Why are the standards shifting? Why do project approvals take so much time in regard to the rebuilding and repair? These were issues that we also dealt with in many islands in the Philippines. And this is not a one-off problem. This is a perennial problem that's been taking place for a long time. I can't emphasize why we at Notre Dame especially wanted to allocate and devote our resources to helping out in this scenario, because this is the frontier of vulnerability that doesn't seem to galvanize as many lawyers as it should and it could towards this effort. And so we're very grateful for everybody who has joined the panel today, and hopefully we will keep collaborating together. I think there's an answer from Zachary.
Yeah, please take it on, Zachary.
Hello, thank you very much. I just wanted to echo the sentiments raised by Ms. Desierto. I think that it's very important that we work in tandem with other areas. That's something that the government of Antigua and Barbuda has been trying to achieve in its interactions, both internationally, whether it be bilaterally or multilateral. But I think that's something that needs to be echoed across, well, small island developing states generally, as well as amongst other developing countries and amongst the wider community for those who are trying to seek climate justice. A point that I would like to note here as well is that while coordination is very important and coordination is needed, it is very difficult for SIDS to do it alone. The example I always give is that I work at the Attorney General's office, and there overall for the country, the Attorney General hires about 12 or so attorneys who are excellent at what they do, the best of the best. However, 12 people are only capable to do so much. And then within the 12 persons, those who are assigned issues of international law, there are only 3 people. So 3 people are advising the government on their international obligations. Even if we took the entire Attorney General's office to COP, for example, we would not be able to participate in the entirety of the monstrosity that COP is. So I say all of that to say that definitely would agree. We need coordination on multiple fronts, whether it be legal, political, and the actual impact zones, the vulnerable communities, as well as leadership. And thanks again for Diane for pointing that out. Our leaders need to be empowered to be able to answer and to respond and to say vehemently, no, we cannot accept this. And that coordination has to happen amongst those who are impoverished and vulnerable, but also with the assistance of those who are able to give that assistance. And the last point I would make is that I also think we are at a turning point where amongst small island developing states, that where it is, if we do not make these strong determinations now, then there may not be a situation later on that we can revisit. And a lot of persons don't think that's a reality, but I can speak with those who live in the Pacific. There are literally islands that are underwater already. So it's not far-fetched. And with that, I'll pass on to the next speaker.
Thank you, Zachary. I will turn now to Professor Seger.
Cordonnier Seger. But yes, thank you. I think I'll just underline, Diane, I think you were speaking of paragraph 66, the tribunal notes that climate change represents an existential threat and raises human rights concerns, which, given that it's coming from the International Tribunal on the Law of the Sea, is a very, very strong recognition. And it's a recognition that goes beyond, if one reads through the judgment, the simple considerations of how the Law of the Sea regime, immense though it may be, needs to respond to climate change, because they are very clear in their judgment that simply signing the Paris Agreement or committing to implement it does not discharge legal obligations internationally or in terms of domestic enforcement, domestic liability and compensation, domestic governance changes. And that all international legal regimes will have to respond in their way to the threat, the existential threat, and human rights concerns of climate change. And so I think this relates directly to the question that Professor Jean-Marc brought forward from the Q&A, because when countries and communities are looking for ways to be able to cooperate on sustainable development. I spent for my sins several years as head of the Sustainable Economic Development Department at the International Development Law Organization. And our member countries through the UN would ask us for assistance with legal preparedness for climate change and other steps. The first thing that we did was to work on addressing that gap that Advocate Zachary has just underlined so eloquently. You know, this challenge of having so few people and such a momentous task. What Professor Diane, of course, has done is handed us some crucial tools, but the work that still needs to be done going forward for each country and also internationally involves first looking at the places where those obstacles still exist. And I will be very frank with all of us here, and I don't think it's a surprise to hear, the law has not always been on the side of the angels on this one. The law for centuries has worked very hard to protect certain interests at the expense of all others. And what Professor Diane is doing with this study, and what all of you are doing with your work, is to try to sort of reset that balance. And going through the existing legal structures, finding the areas where those barriers have been embedded, and finding ways to take them down is sometimes one of the first steps. It's like, not turning on the air conditioning while the windows are open. First, you find all the places where the windows are open, and in a way that's sort of the first step that needs to be done. It should be done, yes, together with all of those who owe a duty of care and a duty of cooperation. But it also needs to be led by and done by those who are, of course, living in the country and are affected by the impacts. And there, I think, especially the young people in our area, the young lawyers who are just coming out of their articles or just coming out of law school and are able to assess their own country's laws with a very clear eye, have been maybe our strongest allies, even if, and it's now 20 years later, I'm still writing their reference letters as they move up to become deputy ministers and other things in their countries. And I think to sort of follow through on my response to the question, one last point, putting together a strategy for legal and governance change, and indeed for change on all areas and disciplines, in order to be able to achieve the most important sustainable development goals for your country in the face of that existential threat that raises those human rights concerns, as has just been recognized in one of our world's highest courts. In the face of that, it requires great courage. It requires great commitment. And of course, it requires the systems and the accountability and the transparency for compliance. And I think that is still one of the most significant challenges that we face in the justice community, is to strengthen that courage, that commitment, that compliance in the conditions we face. I'll stop there.
Well, I think now we are over time. I really thank you. Our thanks to our esteemed panelists for your insightful presentations and thought-provoking comments. Your expertise and perspective have enriched our understanding of the critical issues facing small island developing states and in the context of climate change. Your contributions have shed light on the urgent need for collective action and cooperation to address the existential threat posed by climate change. We appreciate your time and commitment to this important discussion. And those that are joining from the Pacific, I know now it's 3 in the morning. We appreciate that. And again, thank you for your valuable insight and expertise. Thank you to those attending from around the globe. It was unfortunate we didn't have time to take more questions. All we can say is let's work together to address the climate emergency and safeguard the future of SIDS. Thank you again.